Welcome, friends, to the Here I Go Again podcast, where we discuss life, faith, politics, and a whole lot more. I'm your host, Rob Standridge, and I'm glad you're joining us today. So with that, here we go. All right, welcome to the Here I Go Again podcast. Today, we're welcoming my good friend, Dr. Michael Farris, usually from Virginia, but he's in parts unknown, I think, today. So welcome, Mike. How are things going?
Well, good. I'm at the National Religious Broadcasters Convention in Tennessee, and so it's going well. It's an interesting place to be. I enjoy working with people who want to share the gospel of Jesus Christ.
Let's get them closer to the narrow road if we can. Thank you for your evangelism and your work on behalf of, I guess, God or kingdom or whatever you want to say. So thank you, Mike.
There we go.
I want to tease one little thing before I go. And I did this with our friend Mark Meckler the other day, but a couple of weeks ago, I think you're aware of this, but we had some folks in Oklahoma City doing I would call it an anti-Constitution rally, if you will, demeaning our founders, not necessarily bad people, but just really being harsh on those that kind of started this whole thing that we call America. So I want to get back to that. But before we do, I know a lot of our listeners, a lot of the folks that's going to tune into this, they want to meet Mike Farris, Dr. Farris. They know the great things you've done, especially here in Oklahoma. So I want to talk through that. So I've looked at some of the things you've done that I wasn't aware of before we met just a few years ago. But some of the things you did early. So if you could walk us through kind of, where you came from, your childhood a little bit, and what got you interested in, growing the kingdom and how that intersects with politics, is I think that's kind of where I see your past developing.
Well, I was born in Arkansas, so an adjacent state to Oklahoma, and I had an uncle who lived in Tulsa, so I spent a number of times in visiting my family in Oklahoma as I was growing up. But our family moved to Washington State when I was 3, and my dad was a school principal, and I got interested in political life by reading the newspaper every day from the time I was about 6 years old. And one day when I was about 10, my dad and I were changing irrigation pipe, and I was talking about being interested in politics. He says, well, Mike, if you want to be involved in politics, you need to become a lawyer like Mr. Moorback there. And he pointed to a house across the field, and he said, lawyers make $20,000 a year. And that was like saying lawyers make 8 Cadillacs a year. And so ever since then, I wanted to be a lawyer. And as things went on, I became a little more focused that I wanted to be a lawyer in the constitutional arena particularly, and for the cause of Christ in some way, shape, or form. But the exact details were a mystery to me. And have unfolded over the years. But I started off in a small private law firm in Spokane, Washington, with a Christian partner, Ray Eberly. And shortly after that, I got involved in full-time Christian legal political work. I started off founding the Moral Majority of Washington State. A couple of years later, I founded the Homeschool Legal Defense Association. In the meantime, I got hired by Beverly LaHaye to open the Office of Concerned Women for America in Washington, D.C. I worked for the LaHayes. I mean, officially for Bev, but if you work for Bev LaHaye, you also work for Tim LaHaye. So they were very, very close, kind of a second set of parents to me. And I worked for them for 6 years while HSLDA was kind of getting a little bigger. But then about 1985, approximately, I went to work full-time for HSLDA that I started. So I led the homeschooling legal movement I'm still the chairman of the board now 43 years later, but I was full-time president and then chairman for about 35 years, and had the privilege of being involved in all the legal fights to make sure that homeschooling rights, which are God-given, were recognized by the various states through either litigation or legislation, or sometimes both. And so many, 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 many homeschool cases over the years. And eventually I started Patrick Henry College, and it opened in 2000. which is Christian liberal arts school, classically oriented. And I taught constitutional law and coached our moot court team. And the moot court team has now won 14 national championships. I coached 11 of those teams that won the national championship. And then the reason I stopped coaching is because I became the president of Alliance Defending Freedom, which is the largest conservative Christian legal organization in the world. And I led that organization for just about 6 years. We had about 12 cases in the Supreme Court. I argued one of them while I was there. It was my second trip to the Supreme Court. And but we had 12 cases while I was CEO, and we won 11 of those in the Supreme Court,
Wow.
including the Dobbs case. We were co-counsel to the state of Mississippi in that case, and their Solicitor General argued the case. He did a fantastic job, but we were support to them in that case. And so I was on the legal team that helped reverse Roe versus Wade. And so that was one of the highlights of my life. So that's kind of the USA Today version of all that story, Rob. I left a few things out, like starting a newspaper recycling company that failed utterly. It was called Use News. And it was a great name, but it didn't work. It didn't work. So anyhow, there you go.
Well, that's an example from failure breeds success, although that's kind of I don't even know if that's a real failure, Mike. But So on this Dobbs case, I mean, people hear the term Dobbs. I mean, as you know, I became a lawyer later in life, so I'm intrigued, maybe more even than you are. But to you, this is simple. But we had a discussion about this cause of action, if you will, just for those, just to kind of a brief, how is it that the Dobbs case is unique? What is the law that essentially overturned Roe v. Wade? I know you were involved in that. That's why I'm going to ask you about that. So what is it about that case that got it propelled all the way to the Supreme Court?
Well, the law was written to ban abortions after 15 weeks. And the original hope was that we could put a crack in Roe versus Wade, because we didn't think that Chief Justice Roberts would agree to overturning the case in one fell swoop, if you will, because he seems to like to do things of that nature. He'll do it, but he likes to do it in two steps. First he'll undermine an old bad principle, and then he'll reverse it in a subsequent case. And so this law was designed to do that. But then, as we were working our way through the system, and as it was getting to the Supreme Court, Ruth Bader Ginsburg passed away, and she was replaced by Amy Coney Barrett. And now the reversal became very much of a real option. And so the decision was made ultimately by the Attorney General of Mississippi, and she did a fantastic job and was very courageous and made the call that we were going to go for it and seek to reverse Roe versus Wade. Of course, ADF was thrilled with her decision, but it was her authority. She was defending the law. So the way you get a case to the Supreme Court like this is you write a law that either undermines or completely challenges, effectively say, we're going to pass the law anyway, despite Roe versus Wade. You're effectively passing a law that seems to confront a Supreme Court precedent. And so then somebody challenges that law using the old precedent. And then when it's a state law like this, the Attorney General moves in to defend the law. And then people come alongside to help him defend the law. And they often will hire groups like the Attorney Generals of Idaho and West Virginia have hired, not for money, but for authority, Alliance Defending Freedom, to defend their sports bills that say only girls can play girls' sports, but men can't play girls' sports. And so usually the attorney generals of the states will defend their own laws. Sometimes they get outside help to do that. And so in this case, Mississippi defended its law, but with our help, we loaned them full-time counsel. We helped them with every stage of the briefing. But So it was a partnership. They asked us to be silent partners and stay out of the limelight until it was all done. And then when it was all done, they acknowledged our role and thanked us. And of course, we thank them for the privilege of being able to help on the most important case that any of us will probably ever work on.
So based on your experience with that, Mike, do you think there's a chance that a state will get the Supreme Court to revisit Obergefell, since that, to me, that seems like that's deriving from that same right of privacy that we saw under Roe v. Wade?
Yeah, well, I don't think there's currently 5 votes on the Supreme Court to do that. I think they should, but
should be a state issue, right, Mike?
Yeah, it should be a state issue, and so I don't see that as likely. But if everybody would vote, I mean, like if Chief Justice Roberts would vote the same way he did on Obergefell, then you probably do have 5 votes. But I don't know that he would vote for it now. So I don't know. I mean, it's a hard thing, but it doesn't mean it shouldn't be tried. But it's going to take a state passing a new law that effectively defies Obergefell for that to happen. And then you have to have a courageous attorney general who will step up and say, we're going to go for it. And, we have to see what, to paraphrase the Chronicles of Narnia, we have to see what adventures Aslan sends our way.
That's right. It's a good analogy. I know you saw the Supreme Court decision on the tariffs, but that's kind of new. And I've already read the president's response. I'm pretty encouraged by his response because that seemed to be such a centerpiece of his both diplomacy internationally and domestic policy. So I don't want to get too deep into that. But back on law, though, on the HSLDA, the Oklahoma, we have a lot of homeschoolers, and I have a lot of friends that homeschool in Oklahoma. Do you recall any cases that directly impacted or at least indirectly impacted Oklahoma homeschool parents that you can recall? I don't want to put you on the spot, but do you recall any cases?
Well, no. Oklahoma was a fairly quiet state. I mean, we had some issues, but they weren't of the big kind of out and out fights that we had in some other states. Oklahoma came into the fold of being a pro homeschool state comparatively quietly, but the same basic thing was true in every state, is that you had to have parents willing to stand up for their rights, and you had to have a combination of litigators who would fight for them, and then you had to have a state organization that would bring the case to the state legislature, and which was local people talking to local legislatures. There's enormous power in that. It doesn't mean that somebody like me, who is a subject matter expert on something, can't come in and help, but it's ultimately the power of the grassroots working with the individual legislative leaders to get stuff done. And so it took about 25 years and to get all 50 states to recognize our God-given right to homeschool. No state gave us the right to homeschool. They merely recognized the God-given right. And some of them recognized it more freely than others, but nonetheless, the basic legality of homeschooling was established in all 50 states over about a 25-year period in the face of significant opposition from the teachers union and other elements of the education establishment. Oftentimes it's the superintendents against the teachers union or the school boards against the teachers union. In our case, it was the entire education establishment against the homeschooling families. But through the persistence of homeschoolers, through hard work, through some litigation, but mostly through the power and blessing of God, we saw that right being recognized in all 50 states.
Which was the most difficult state? Which is the most anti-homeschool state that you?
Right. Well, North Dakota was probably the most difficult, but coming in real close behind them was Michigan and Iowa. um, all 3 states held on to the bitter end to the rule that you had to have a teaching certificate in order to teach your kids.
Oh my
Um,
gosh. Okay.
and we there was actually one study done that found that there was really no material difference between a kid's achievement if the parent was a certified teacher, if one parent was a certified teacher, and parents who were not certified. Basically, no difference. But if both parents were certified, then the scores plummeted. Uh, and
Oh,
so
nice. Okay.
the
No
net
offense,
result of that,
certified teachers, but yeah, that's an
yeah,
interesting
yeah,
stat.
yeah. So the net result of that is don't get your kids around too many certified teachers.
Well, not especially if they're both OEA or NEA members for sure.
Right,
So,
exactly.
okay, from one aspiring author, that would be me.
Yeah,
I've written a couple books here recently, and I know when I mean, you've written in your career, so to speak, Mike. You've written a number of books, and
yeah,
I've put some of those on the screen in the background. And
yeah.
so,
It's very
how
kind
many
of you.
how many books, and I'll when we post this I'll start putting links to stuff like that, but
Okay.
what is
All right.
how many books have you written, Mike?
15 have been published.
15.
Yeah, 1 5.
1 5. Wow,
Yeah,
that's cool.
1 5.
So
Yeah.
do
And
you have a favorite? I know you some of your
well,
books obviously are faith-based and you're trying to help moms
yeah.
and
Well,
families, but what's your favorite?
I wrote 3 novels that were, kind of Christian John Grisham books, and I really enjoyed those a lot.
Oh, okay.
Had a lot of, yeah, but the most successful book I've had by a long shot is was called "What a Dad Does for His Daughters,"
Oh, yeah.
and so that was I've sold more of that than anything else, and so it was very successful. I'm writing another book right now on the kind of this current state of our political affairs, which I think is, um, we've got 2 factions that I think are trying to drive off the nation off of both a fiscal cliff and a moral cliff. At about there's a blue squad that wants to drive off the cliff a little slower than the red squad wants to go a little slower than the blue squad, but they're both driving us off the cliff. One at 150 miles an hour and the other 170 miles an hour. But there's not a lot of ultimate difference between those 2 speeds. And then we've got a couple of vultures hanging out, ready to pounce on the country when these people kill it. One's the AOC, New York City mayor, socialist left that's ready to pounce. And then there's some totalitarians arising on the right that are ready to pounce. They're anti-Semitic, anti-Constitution. There's one group that believes in particular that we should all be forced to be Catholic, and we should do away with religious freedom and the freedom of speech. And they're called the integralists, and they have Harvard law professors and others behind them. And so it's, not a lot of people, but a lot of political and intellectual weight behind it. And so there are dangerous folks out there. And what we need to do is to renew our vows to the Declaration of Independence and say that all men are created equal. We're endowed by God with inalienable rights, and that government is created for the protection of those rights, not for any other purpose. The basic problem with government in this country is it doesn't know what its purpose is. The purpose is not to provide for the needs of the people. That's socialism. The purpose is to protect our God-given rights. And when we get the purpose right and we live under the principles of enumerated powers, then we have a shot. But in the meantime, we're going to destroy this country in a big way. The national debt by itself is enough to destroy the country, but there are other things too.
So, do you have a working title yet for that? You and I have visited briefly about what your current project.
Renewing our vows.
Renewing our vows. Oh, I like it. I like it. That's good.
Yeah.
Well, let us know when you get some teasers on that, or when you get ready to get it out there, and I will take a copy for sure. So, Patrick Henry College. So I hear about that in Oklahoma because I assume you have some Oklahoma students there.
Absolutely.
I know it's a pride and joy for you. It's a little Jeffersonian, if you don't mind, Mike. But how did that come about? And I know it's HSLDA. It's kind of somewhat of a partnership, but was this an idea from the beginning, or was it born out of HSLDA, or how did that come about?
Well, HSLDA was about almost 20 years old when we started talking about Patrick Henry College. And the specific conversation arose out of a conversation we had with a Christian radio financial advisor guy. There's kind of, his name was Larry Burkett, and he was kind of the precursor of some of the more, now pretty famous political or financial advisors that, Dave Ramsey and that sort of thing. But he was an early Dave Ramsey, and he was going to speak to the HSLDA conference that we put on every year. We don't put on conferences for rank and file homeschoolers. The state organizations do that. And we want to support the state organizations. So we go speak at their conferences, but we hold a conference for state leaders to encourage them. And so we had Larry Burkett as one of our principal speakers at one of our conference for state leaders. And I asked his scheduler if we could have him meet with our board a little before his speech so we could ask him some financial questions. And she said yes. And so he walked into the room, and I could tell from his body language that he thought we were, deeply in debt, and we needed advice on how to get out of debt and what's our, how are we going to raise enough money and blah, blah, blah. And so he sat down, and I said, Mr. Burkett, thank you for meeting with us. Here's the basic situation. I don't remember exact numbers anymore, but I'll be close. And I said, we've been in existence, I think, about 17 years, and we've saved several $1 million. It's more than $10 million. And we don't know what we're supposed to do with it. And so his countenance changed. And he said, well, God didn't give you the money to sit on it. He gave it to you to serve the people he's called to serve. And so we asked him, what amount should we have for a proper reserve? And he told us. And, how should we invest that? And he told us. But we had a whole lot more than a proper reserve. And so we held another meeting to answer the question, how can we serve the people God's called us to serve in a way that nobody else can pull off? And so we did a few things. We gave a pretty good sized grant to an organization that was helping homeschool families with special needs kids. But we still had a lot of money, millions of dollars left over. And so because a number of families had asked for information about colleges that had a pattern to them, they wanted something that was thoroughly biblical. And there are about a dozen colleges in the country, liberal arts colleges, that I would give a thumbs up on biblical fidelity. There's a lot more that are what J. Vernon McKee once said, there are believers, there are non-believers, and there are make-believers. And I'm not interested in make-believer colleges, but there are about a dozen or so, good, solid, Bible-believing liberal arts colleges. But none of them are really academically challenging, or the kind of the top end of the academics. And none of them, at least until we started, had a classical orientation. And so, and then finally, we were looking for something with an apprenticeship orientation for your major, where you got on-the-job experience. And so what Patrick Henry College did was blend all those things together in response to the questions we were getting from families. I was getting questions from members of Congress who said that they wanted to hire a sharp homeschool kid, and I knew they didn't want a 14-year-old. And so Tom Coburn hired a young lady who now is Jane Treat and lives in Oklahoma, and married a young man from his staff. But Jane went to work for Senator Coburn, and was one of our early people doing that, because people wanted faithful, well-trained, well-educated, able to write and research at a very high level. And so that was the original vision of the college. And we got going in 2000, and it's been very successful academically. It has grown slowly, but it is growing, and slightly more guys than girls, which is very unusual in colleges these days. And Lots and lots of kids go to law school. A lot of them become work in the intelligence industry, and then beyond that, all kinds of different things. Any number of different things. We have one member of Congress who's one of our graduates, and he's from Colorado.
Who is that, Mike?
His name is Gabe Evans from Colorado.
Okay.
And then some are in, like there's a county treasurer in Oklahoma. There's a PhD graduate, and others in various positions around the country. So it's been a great experience. And our forte is debate, particularly legal debate. We've won more national championships in legal debate than any other college in the country by a long shot. The second place has won 2. We've won 14.
Oh my gosh.
So last year, the national finals were Yale versus Patrick Henry. It was Yale's first trip to the national finals, and we won. And it was our 14th national championship, and we probably have won another 14 where we were second place, partly because you can win both places. We have at least 5 or 6 occasions, I think. I don't remember exactly, but on several occasions, won both first and second place in the national championship. So we're good at that. We're kind of like UCLA under John Wooden.
That's good. So I know you went back. You've taught at Patrick Henry some, correct? I believe you have.
For 17 years, I taught constitutional law and coached the moot court team.
So you coached the team during that entire 14 years? Wow.
Yeah, 17 years, yeah.
Well, I've seen you firsthand debating in a pretty casual setting, and I would say I wouldn't want to go up against you. So I assume your students are similar. But you mentioned, it's odd that you mentioned this idea on the Catholic. And I'm sure we're not besmirching Catholics for sure, but
no, it's a very minority element within Catholicism. It's not the mainstream Catholics, not the official position of the Catholic Church. It's just there's a group of Catholics, a small group of Catholics who are kind of their little radical fringe group.
So, but that's interesting that you mentioned that, because in thinking about doing a podcast for months, I started listening to these, and I really enjoy the conspiracy ones, actually. And there's one of them that on the Constitution, for instance, that claims that the Pope, or the Black Pope, I get confused on all of that, but that somehow they were, we'll get to constitutional controversies here in a minute, but I found that interesting that some people out there believe that the King and the Pope all teamed together and forced us to sign our Constitution. I don't know if you've ever heard that conspiracy theory, but it's bizarre.
No, somebody's not just drinking Kool-Aid. They're drinking shoe polish Kool-Aid and some gasoline to come up with that nonsense.
I know. Yeah. So there's stuff. Well, and if even during the discussions, of course, they're one way. You don't get to interject your opinion, but I always find it interesting when you listen to these things. They always say, "Well, you can find it on the internet. It's all out there." And I'm going, "Oh, okay. Well, that makes it all good."
Yeah.
So you mentioned Coburn's name, a mentor and friend of mine, and I know as we move closer to these constitutional issues. So did you, because of Jane, did you have an interaction with Coburn before Convention of States, or was that?
Yes. Well, it wasn't just because of Jane, but I had worked with him in the Senate in a variety of ways. Not every day by any means, but enough that we knew who each other were. Obviously, I knew who he was, but we had interacted on homeschooling things and just other issues over the years. But got to work with him a whole lot more closely on a very close and intimate basis when he left the Senate and came as an advocate for the Convention of States project.
I had my friend Josh McKean, who's a friend of yours as well, on my first podcast, and we talked about this Article 5 process, something that I know you're familiar with. So I was late to the party, if you will. I came to that concept through Josh and personal study. So we also had a visit with just because of scheduling. I actually visited with Mark Meckler, a mutual friend of ours and a close compatriot of yours, and we talked about the genesis of at least the modern thinking of reigning in the federal government through the Constitution. So you're an expert in this. When did this start when did you start thinking that usage of the Constitution, Article 5, might be a method to rein in an out of control federal government?
Well, it was about 15 years ago that I really started focusing on it. I was aware of it because of litigation I did that started in the late 70s into the early 80s on the process of ratifying the Equal Rights Amendment. Congress changed the rules late in the process to try to extend the deadline for ratifying the ERA. And so I filed on behalf of 4 Washington state legislators the first legal challenge to that act of Congress. Now, there was a similar case, frankly, a little better put together, that was filed about 2 weeks later by the Attorney General of Idaho and Mountain States Legal Foundation, and it was in Boise. And for a variety of reasons, I thought their case was, in a better position. So I dismissed mine on the same day that I dismissed my case in Tacoma, Washington. I jumped on an airplane, flew to Boise, moved to intervene in their case, and the judge granted the motion the same day. So I became a junior partner in their case. I got to argue parts of the case in oral argument, but the Idaho Attorney General, and then a guy named David Leroy, that was the Attorney General. It was John Rumpf, who was in private practice in Boise, were the lead attorneys in the case, and I was kind of third, if you will. And it was a great experience, and I learned the process of amending the Constitution inside out and backwards. One of the things I did is I was tasked to go to National Archives and look at all the ratification documents in the history of the country since the 13th Amendment. It was a lot harder to get the Bill of Rights ratifications. You had to have a different, and I didn't really need that for what I was doing. So I just started with the 13th Amendment, went forward to modern times, and physically handled every single ratification document and read it over to see if they'd done it correctly. So that was one of my assignments, and it was, it got me deep into the National Archives, and I learned the process at a deep level. But about 15 years ago, I started recognizing that we've got these problems with too much federal spending, too much federal power, too much power, the federal government taking over things that belong to the state governments, or even more, that belong to the people who don't belong to any government. And so knowing what I knew about Article 5, and having lived and worked in Washington, D.C. for about 3 decades at that point in time, I knew that Congress was never going to fix any of these things itself. And I knew that George Mason put the convention process into the Constitution in the last week of the Constitutional Convention for the express reason that he knew that Congress would never propose power limitations on itself. And, and in fact, the whole idea of checks and balances prohibits us from relying on an agency checking itself. It's just not going to happen. And so, they wrote the Constitution for a bunch of sinners. They all believe the Christian worldview that all men are sinners, and that you should never trust any sinner with too much power. We should have limited powers, enumerated powers, checks and balances, federalism, and the whole nature of limited government power. And so they gave the states the unilateral ability to amend the Constitution, as long as enough states joined in, and to override the natural inclination of the federal government to want to expand its power. So I started talking about this on my Facebook page, and Mark Meckler's chairman of the board of his nonprofit, his wife was reading my Facebook page, and she told her husband he needed to look what I was talking about, and that led to me meeting Mark Meckler, and he loved my idea after studying it, and he brought the mechanism and the organizational machinery and all the original fundraising to bear. And I was kind of the idea guy, and they were the make it happen guys. And so Mark and I were the co-founders of it, with having those two kind of zones of responsibility.
So backing up just a little bit to this, your first case. That sounds very intriguing for an attorney to dig
Yeah.
through those ratifications like Nicolas Cage
Well,
there, but blowing the dust off. But
yeah.
so when you went through that, so I assume that you lost the case and Congress does have the power to manipulate the date, correct?
No, we won.
Okay.
Uh,
Well, wait a
yeah.
minute, because I thought Congress had everything to say about Article 5 and Convention of States. That's what I've heard.
Yeah. Well, that's what people say who don't know what they're talking about. I mean, there's a throwaway line in one case called Coleman versus Miller from, I think it's 1930, but I'm not more than a year or so. And that would lead you to that impression. But that ignores a bunch of other Supreme Court cases that say quite to the contrary, that, Congress does not have the power. I mean, for one thing, in the ERA, Congress was trying to act with a simple majority vote and the president's signature. Well, you can't do that. The president has no power. That's a long-established principle. The president has no power vis-a-vis Article 5 matters. Only, 2/3 of both houses of Congress. So a simple majority plus the president doesn't give them the ability to act at all under Article 5, period. Now, not only that, the judge also said, once they've acted, they're done. They can't, they have no continuing supervision over it. They handed it to the states to ratify it. Congress can't intervene. They can't change the rules. If they send it out to say 7 years, it's 7 years. If they send it out to say 50 years, it's 50 years. Whatever they said initially, but they can't rein it in or they can't take it back or expand it. They're done. So the idea that Congress can do anything they want is just nonsense. And the other idea is that all these questions are non-justiciable, meaning courts can't decide these cases. There's 6 Supreme Court cases that say just this, that they're not only justiciable, that mean the court actually decided them on the merits, but the 6 cases all said state constitutions can't change the process of adopting constitutional amendments for the U.S. Constitution. The federal Constitution says that, not the federal government. It's not Congress can control everything. Article 5 controls everything. And so, and I won a case in Kansas about 4 or 5 months ago on that same exact principle, getting a portion of the Kansas Constitution declared unconstitutional. So the idea that these cases are non-justiciable, that courts can't decide them, it's just up to Congress to decide. I've won 2 cases in my life on that very point.
What was the case in Kansas, Mike?
The Kansas Constitution imposed a supermajority for voting on federal constitutional amendments, either to call a convention or to ratify. And that was in direct contradiction of the 6 Supreme Court cases that say that state constitutions can't control it. And it's because who enacts state constitutions? The answer ultimately is the people of the state. The people vote on them to ratify them in every state. And the only people that have power, Article 5 power, are the state legislators, not the governor, not the people, not the state constitution, the state legislators using the power they get directly from the U.S. Constitution. And so, people will say, well, this is a federal matter and therefore Congress controls it. No. It's a constitutional matter, and the relevant power has been delegated not to Congress, but to the state legislature. So the things that the Constitution gives to the states, the state legislatures are acting under the authority of the United States Constitution. They are not acting under the authority of their state constitution. And although my Kansas case was the first time that principle had been applied to the convention side of the equation, when you got 6 cases from the Supreme Court of the United States on the second phase, on the ratification phase, it's not a hard thing for the federal judge to say, they're in the same sentence in the Constitution, same rules apply here. And so that's what the judge said and issued a very good opinion. And it's final now. And Kansas has now voted to adopt the Convention of States.
So just so that because we kind of hopped into this, but the just so that viewers, listeners know what is that provision we're talking about. It was born out of, I mean, it was George Mason, as you mentioned, and then I believe James Madison put it forward, unanimous vote, and it was about the state's power underneath the Constitution. But just so the listeners watching, can you just in short form tell us
Sure. Yeah.
how does that work?
Okay. The Constitution, after the motion that was inspired by Mason, he didn't write the formal motion, but it was his speech that led to the motion. And it gave us two ways to propose amendments. Congress can propose amendments when 2/3 of both houses of Congress propose a text. It also gave the states the ability to propose amendments when 2/3 of all the state legislatures call for a convention on a particular topic. And then it has to be ratified by 34 states. And there are two ways it can be ratified. And Congress gets to choose which of these two ways are ratified, either by state ratification conventions, which are special meetings called by delegates elected by the people for this specific purpose. They can ratify constitutional amendments. That's only been done once in our history, and that was for the 21st Amendment to repeal prohibition. All the other times, the Congress has chosen to send the matter to the state legislatures, I should say, to vote on ratifying. And when 3/4 of the states ratify, then it's an amendment. So the process is 34 states have to propose a convention on a particular topic. 26 states at the convention, a majority, have to vote to approve the proposed topic that's sent out, the proposed language of an amendment that's sent to the states for ratification. And then both houses in 38 states have to vote to approve whatever comes out. That's a very hard process. Not impossible, but very hard. It should be hard. Our founders didn't want us changing the Constitution on a whim. They wanted to do things where there was an overwhelming consensus that this was the right thing to do. And so that's the process in place. And our particular effort is at 20 states. So we need 14 more states if we're going to have a convention that does three things. It considers fiscal restraints on the federal government, term limits on federal officials, not just the members of Congress, but high elected or high appointed officials like Dr. Fauci would have to have term limits if this goes through the whole process. And then third is other general restrictions on the power and jurisdiction of the federal government, not increasing the power. It's restrictions only. So anything that would restrain the power, like, for example, Congress has the ability to change the number of Supreme Court justices. A restraint of power would be to take away the ability of Congress to name as many Supreme Court justices. So we get rid of the idea of court packing. Uh-huh. And that would be one example of a restraint on the jurisdiction of Congress. Another one would be to have a single subject rule, like 43 states rather, have in their state constitutions a rule that says you can't have bills that are a conglomeration of a bunch of topics. You have to have a bill on a single subject. And if we did that, we'd have no more 5,000-page bills where people don't even know what's in the legislation. But Congress would have to vote on each of these things separately. And that would do away with a lot of nonsense. And so that would be an example of taking away the power of Congress to have unlimited bill length and unlimited subjects, and say, no, you can only vote on a single subject at a time. That would be a limitation in congressional power.
Well, yeah, and so these amendments, I want to dig into what I call the Article 5 dragons, these fears that are propagated. But before that, there's one thing that I've heard said that these amendments, the Congress, the country won't abide by them, and so maybe to kind of allay that fear, if you will, what are we still don't have slavery again, right? Women are still voting. Presidents still have 2 terms. What do you think about that kind of strange comment?
Well, the parts of the Constitution that are not being obeyed according to their original meaning, the parts of the Constitution is being obeyed according to the Supreme Court's interpretation of the Constitution. Now, does the Supreme Court get it right? Once in a while, yeah.
Would you kind of call that, as George Mason or James Madison said, wouldn't you call
Yeah.
that an error, kind of? Wouldn't you call that an
Yeah,
error?
yeah, that's an error. And so and it's basically, I mean, the bottom line problem is law schools for about 100 years have been teaching what's called the living Constitution. And so instead of teaching originalism. And so judges think it's their duty to reinterpret the meaning of words for what they think it should mean today rather than what it meant when it was written. And we don't have the rule of law if judges can change the meaning according to their own personal philosophy. And that's what's going on. Now, we are doing a lot better at the Supreme Court level than we used to because we have 6 justices that at least say they adhere to that principle. In fact, they do adhere to the principle. Now, there's debates between originalists about particular outcomes of particular cases, but they agree that originalism is the right way to interpret the Constitution. And so we've never had 6 in my lifetime that agreed until now. And so the Supreme Court itself is much better. And there are many more federal court justices that are or judges, I should say, that are originalists than used to be. And so the ability of to win properly in court is better than it has been in a long time. But it's still overwhelmingly by people who can't follow the Constitution correctly because they've been trained in law school to believe in living constitutionalism. That's the basic problem. But all that to say, back to the amendments. Amendments written well are obeyed. The 13th Amendment bans slavery. The 14th Amendment says Black people need to be treated equally with white people. And frankly, it's a broader principle than that. Nobody can be treated unequally because of their race. And so, that's being enforced correctly, basically. And, the 15th Amendment gave people the right to vote no matter their skin color. That's working. The 19th Amendment gave women the right to vote. That's working. The president has 2 terms. That's working. 18-year-olds can vote. That's working. So a properly written amendment will be enforced. It's mostly the Commerce Clause and the General Welfare Clause that are not being interpreted correctly. And we can fix those things with an amendment that effectively correctly interprets those things, and we get back to limited federal government. But can things be interpreted improperly? Yeah. Do they always? No. Properly written amendments will constrain the federal government.
Yeah, I saw a recent. I think one of the things that upset me the most when you hear about, especially those on the right that push back against this movement, is the leftist method of just trashing those that bring it to the table. I mean, they've done that with Coburn, which was unbelievable to me. But recently I saw, I don't know if you've seen this, but they're trying to. So George Mason, the Constitutional Convention, the records there, we don't know exactly what was said. So they're trying to twist the words that's not entirely known about George Mason, trying to say that, well, he said fix the errors. That's why I said errors a minute ago. I think our founders would see that a misinterpretation is an error in their minds, just like the Alien Sedition Acts were a misinterpretation of the executive branch.
Yeah, if they wanted to fix things that proved not to work well, I mean, Mason thought it was an error not to have a Bill of Rights.
Yes.
And so that got fixed. Patrick Henry thought it was an error to give direct taxing power to the federal government. Well, that one hasn't been fixed. But they just were not either drafted right or they haven't been interpreted right. I mean, and who's to say? I mean, in one sense, maybe the Supreme Court, in theory, the Supreme Court is right about the Commerce Clause. Well, if that's the case, then it was an error to write it the way it was written.
Oh, there you go. That's good.
Yeah. So, whatever, it is an error to interpret it the way the Supreme Court is interpreting it today.
I think
That's for sure.
I believe so, and the welfare clause as well, which
Yeah.
was that's kind of the more strange one because that was not even a power really. Uh,
Well, and beyond that, they took it out of the Articles of Confederation word for word. And if you think that the under the Articles of Confederation, Congress could spend money on any fool project they wanted to, which is what the General Welfare Clause means today, you don't know a lick about American history. Because when you lift a clause right out of the Articles of Confederation and put it into the Constitution, you have to ask yourself, what did it mean in the Articles of Confederation? What it meant was when Congress spends money, it's got to do it in a that they're authorized to spend. They got to do it in a way that doesn't favor their friends, doesn't favor some locality. It's for the general welfare of the whole country. That's what it meant. It was a limitation on the power of
yes.
spending, not an open-ended grant on spending power.
Yeah, for sure, for sure. Well, so I think the most getting back to these dragons, and I mean, honestly, Mike, we could spend a long time, and and people can get online and listen to your debates. But I'd like to go over these because I just find some of these very intriguing, almost entertaining, if it wasn't such an important topic. But this whole runaway thing, I talked to Mark a little bit about it the other day. Um, this one is the one that I find the most interesting because in order to establish that that's a valid argument against an Article 5 amendment proposing convention today, proposing being the key word. Article 5 didn't exist in 1787, first off, but that is
Right.
essentially saying our founders, went against everything that they themselves believe in. They rolled over their own states. They felt like more was their home than the actual country. So where did this whole idea, I guess the question is, did this runaway convention idea happen in is this something that's been talked about since 1790, or is this something that's more recent?
Well, the answer is all the above. The original convention call started. The place to start is with the convening of the Annapolis Convention. Virginia asked for a meeting of the states because things were not going well under the Articles of Confederation and something needed to get done. And they decided they can't fix it in Congress under the Articles of Confederation. They needed to do something else. And so they had a meeting. It was an informal meeting. There was no official sanction to it, but it was a meeting of the sovereign states who possessed residual sovereignty. And they came together and they got authority from their state legislators to meet and talk about fixing the problems with commerce. They got there, only about 4 or 5 states showed up, and they quickly realized 2 things. One, we don't have enough states. Number 2, talking about commerce isn't a big enough assignment because there are bigger problems than just commerce. And so they drafted so what was their conclusion? They didn't have the authority to go beyond their instructions. That was the conclusion of the Annapolis Convention. So they said, we've got to go back to our states that gave us the authority to be here in the first place and ask our states for more authority. So they suggested a convention for the purpose of rendering the federal Constitution adequate for the exigencies of the Union. That was the request from the Annapolis Convention. I'm quoting that. And so they went back to the states and asked for permission to hold a convention for those purposes. Virginia was the first state to do that. Other states lined up quickly, and after 6 states had called for convention for rendering the federal Constitution adequate for the exigencies of the Union, and had named their delegates to this convention, then the New York legislature asked Congress, and Congress was meeting in New York City at the time, the New York legislature asked Congress what their view of this was. And Congress passed a non-binding resolution that said, there's this convention that's going to happen in May in Philadelphia, and basically, we think it's a good idea, but they should only amend the Articles of Confederation. So Congress gave that limitation to its opinion of what was going on. Congress did not call the convention. They did not appoint any delegates. They had no control over it whatsoever. It was the states in their residual sovereignty that were acting. And then after that, 6 more states joined the call for a convention, and 9 of the states used Virginia's language exactly, the language from the Annapolis Convention: render the federal constitution adequate for the exigencies of the Union. Connecticut basically paraphrased that. New York adopted the language of Congress, which said only amend the Articles of Confederation. Massachusetts said both. They said render the federal constitution adequate and only amend the articles. And so arguably, potentially, New York's delegates could be held to have violated their instructions, except for one thing. They left the convention and never voted again once it was obvious they were going to adopt a new document. Hamilton stayed as a delegate from New York, but he was not allowed to vote because New York's legislature set a rule that all 3 of their delegates had to be there to cast New York's vote. So New York never voted again. Hamilton debated, helped, drafted, couldn't vote. And so New York did not violate their instructions because they left. Now, Massachusetts, it was ambiguous because they had both the New York instructions and the Virginia instructions in the same document. And there was a motion at the ratification convention in Massachusetts after the Constitution had been passed to condemn the Massachusetts delegates for violating their instructions. And by a 2-to-1 margin, the Massachusetts delegates to the Constitutional Convention rejected that. They believed that their delegates had obeyed their instructions. So when, John Birch Society and their expert witnesses, who my best understanding is their expert is a professional house painter, tries to interpret what Massachusetts delegates, whether the Massachusetts delegates obeyed their instructions or not. You know what? I think the people in Massachusetts immediately after the Constitutional Convention who voted on the very topic, I think they have a little more authority to say what the Massachusetts instructions really meant. And so anyhow, that's the story. The delegates did not disobey their instructions. And there were many times in the convention where they said, well, what do our instructions tell us to do? And every time they went and looked at their state legislation that gave them the authority to act. They never looked at the thing from Congress. Congress did not play any role whatsoever in that. It was just simply like a National Pickle Week resolution. It was an endorsement of what they thought the right thing to do. Now, drilling down for just a second on that, the people claiming to be constitutionalists who argue that the original Constitution was a result of a runaway convention are arguing that the Constitution itself was illegally adopted.
And who presided over that, Mike, that runaway?
Yeah, it was this traitor named George Washington.
Yeah.
Come on. And so the idea that, you say you're a constitutionalist and then argue that the Constitution was illegally adopted. It's like saying you're a Bible-believing Christian, but that, the Illuminati wrote the Bible and not God. Come on. You can't have it both ways. Yeah. Either you believe the Bible or you don't believe the Bible. Either you believe in the Constitution or you don't believe in the Constitution. And the John Birch Society does not believe in the Constitution of the United States. I don't care what they say because they regularly teach that it was illegally adopted. Now, this is the current cast of leaders of the John Birch Society, not the original ones. The first and second presidents of the John Birch Society used the Convention of States process to push an amendment called the Liberty Amendments, and they got several states to call for a convention. Many of them are still in play for, it was a really pretty good amendment. They wanted to repeal income taxes and do some other good things. So that was the original leadership of the John Birch Society. And so the people that are leading it today not only criticize the Constitution itself, they not only criticize George Mason, they implicitly are criticizing the founders of the John Birch Society. Make up your mind whose side you're on. And the fact that they are regularly appearing in state legislatures, arguing side by side with Common Cause and the groups funded by George Soros, I don't know. The talking points are the same. So I don't know where they're getting their money, but I can tell you this. Their message is out of the Democrat left-wing playbook down to the very essence of degrading the legitimacy of the Constitution of the United States. That's, to me, constitutional treason.
Well, when I saw the piece put out on Coburn a few years ago, I looked at that piece and I said, did George Soros write this? Did some, leftist hate group write this about Tom Coburn? Because it was so incredibly misleading and false. And, that was when he was still with us. I haven't seen him republish it, but it wouldn't surprise me if they did, because right now they're deriding, James Madison left and right, the father of our Constitution. And I have to disclaim this. You and I both have friends that are Birch Society folks, and we both respect, I think, many of their positions. But this one, and my friends that are there, and some of them, I wouldn't be surprised tomorrow if they didn't show up at the state capitol in Oklahoma with wife beaters on and muskets in their hands, ready to start a civil war. But yet this idea of fear. And so you talk about the misunderstanding about the Constitutional Convention, but there's this irrational fear from people that say they have no fear today. Is there, I know the Warren Burger, the Justice Burger, but they also essentially quote James Madison in this infamous, I guess you would call it, caution to the states in 1788. Can you walk through that?
Sure. In the Virginia Ratification Convention, Patrick Henry was trying to kill the Constitution. He wanted to defeat it. And even though 9 states had already ratified it, they didn't know about one of them because, mail was slow in those days. So they thought they were going to be the 9th state. But they were debating whether or not Patrick Henry, who I named a college after, so I like Patrick Henry, but I think he was wrong on this one thing. He wanted a Bill of Rights and other amendments before Virginia ratified the convention. Madison ultimately agreed to, propose amendments after the convention was ratified. And so you would be, if you did it Patrick Henry's way, you would have to have a new convention and start over, because you can't use Article 5 to amend the Constitution until it's already adopted. And so if it's not adopted, you go back and you start from scratch. And so you have a whole new convention. And so Madison's comments were aimed at Patrick Henry's plan. They said, no, we don't want to throw this out and start from scratch. If we need to adopt a Bill of Rights, which he reluctantly agreed to, then we need to be able to do it after we've approved the Constitution. And that was the debate. And it was not, and there's other writings of Madison that say, if the federal government misbehaves, you use Article 5 process to fix it. And so, they cherry pick a quote, out of thin air and try to make it mean something it just doesn't mean. It's like people, or criticize you and say, Judas, went out and hanged himself, and then they jump to another verse and, go thou and do likewise. It's cherry picking stuff that doesn't make any sense.
Yeah. Take sentence Z and match it with sentence A, right? Yeah.
Yeah, exactly.
Well, I know you alluded to it, but, Madison later in life, when there was, controversy in the country with the nullification crisis and other alien sedition acts, we hear this term nullification all the time. And I've heard you speak about it quite a bit. And I'm in favor if it works. Which I find this contradiction interesting. You have some folks that have one idea, like let's say your idea is to go storm the Capitol, right? Peacefully, of course. and maybe I say, well, Mike, that won't work. But do I go around trying to cut off everybody's legs so they can't make it to the Capitol? So nullification, I've lost faith in its ability to do much, especially after the Real ID and other things we've tried. But does it mean I'm going to try, if I were in the legislature, pass laws that say you cannot do that? Why is it that they always do this? Why are the John Birch and some others on the far right, I guess you might say, Why are they hell bent on stopping others? Why don't they just focus on doing their own efforts?
It's a good question. I think it's because, bottom line, they're anarchists. They don't want to accomplish anything good. They want to just blow stuff up. Metaphorically. I don't mean with actual explosives. I mean they don't want to have any government at all. They don't really want the Constitution. They really want the Articles of Confederation back, which is a total failure. We would not have the United States of America. That would have about 10 or 15 countries, and that's not that's just not realistic or desirable. But and there are a few things where you could challenge the federal government's jurisdiction. But, how are you going to nullify the national debt? You can't do it. There's just no way. How are you going to nullify all the federal spending that's causing the national debt? You can't do that. How are you going to nullify treaties that are adopted illegally by the sole signature of the president? States can't do that. There are 50 books of laws passed by Congress. There are 250 books of laws passed by the federal agencies. In my opinion, all 250 books are unconstitutional because Congress is supposed to make all the laws, not just some of the laws, not just a fifth of the laws. Well, how are you going to, you couldn't get floor time in state legislatures to nullify all 250 books. There's tens of thousands of individual laws in those 250 books. Whereas our methodology can get rid of all of them. We can, through the votes of 38 states ultimately, get rid of all 250 books. There's no way that nullification can accomplish that. And stuff like that needs to get done. Nullification can't stop court packing. You can't do it. An amendment can stop court packing. And so they're trying to fight weapons with that has arguably a little bit of application here and there. What we see is going on in Minnesota right now is nullification. Minnesota is nullifying federal immigration law.
Yep.
And so you see how well that works. All it does is create chaos and riots and fights. And we're, ultimately, if somebody really wanted to press it, you got a shooting war going on over that. That's where nullification leads you. And, there are times where it's the right thing to try, but it's never a solution to the structural problems that are really what's going on that's really putting our nation at such risk.
Well, Lisa, my wife, she took my spot and she's learning a lot about Article 5 since it's an issue this year at the Capitol. And she had kind of an intriguing a thought exercise, if you will, Mike. So imagine if all of a sudden Congress put forward by 2/3 vote a proposed amendment, which, they put forward thousands, I think, they proposed thousands. Only a few have gotten 2/3 vote, but they propose and actually get 2/3 votes to take out the state's right under Article 5. Would the other side, and I hate to say John Birch Society's other, there's other people besides that, but let's to give it a name, let's say the Birch Society. Would you think that they would go out there and try to get 38 states to ratify to take away the state's power in Article 5?
It's a good question. I think they would. I think that they would. It's
the single most powerful right that our founders gave us as states would take.
Yeah, it doesn't make any sense. It defies. The John Birch Society used to write me up as one of the greatest lawyers in America. Go to AI and ask AI. At least Google AI. I did this. Who was the person outside of Congress responsible for killing the UN Convention on the Rights of the Child? The number one answer is me. You ask it, who was the number one person to kill the UN Convention on the Rights of Persons with Disabilities? The number outside of Congress. The answer is me. And so they love me because I, am dead set against international law taking over a country. And I have an international law degree from the University of London that I got specifically so I could kill treaties that were going to take over the domestic law of the United States. I was going to be hired. I was in the process of working up a case if Biden was going to sign the WHO pandemic treaty and make it an executive agreement, not a Senate ratified treaty, I was going to sue on behalf of U.S. senators. I mean, the senators trusted me on that. I'm an expert on that kind of stuff. And, I'm right aligned with the members of the John Birch Society, but yet somehow I'm a creep and a villain for thinking we should use the tool that's in the Constitution of the United States, that the founders of the John Birch Society also agreed was the right tool. And somehow I'm disloyal to the principles of the country because I want to use the constitutional tools to accomplish the objective of limiting the power of the federal government. Just it doesn't make sense where they get. And so, my ultimate answer is say, bless their heart, let's ignore them, and let's go do what we need to do to fix the country.
I agree completely. I think it's hard to ignore because they do have some force in some states. But going back to the Patrick Henry and the Bill of Rights, it's such for anybody that likes politics or the law, you got to grab a book, you got to read about this. It's such an intriguing time. I've got multi-volume sets, not the whole 38 like you probably have, but to me, the Bill of Rights essentially was an Article 5 process, very similar, even though Congress was involved, very much an Article 5 process like we're talking about today. Would you agree with that?
Well, it was started because Virginia passed a resolution under Article 5 to call for amendments that included the Bill of Rights. And Madison promised the Baptist churches from Orange County, Virginia, Pastor James Leland and others, that he would push forward a Bill of Rights. And so, there have been a number of constitutional amendments that have been adopted because you got really close to having 2/3 of the states call for a convention for that purpose, and Congress saw the handwriting on the wall, and they passed amendments to accomplish that purpose. And so the Bill of Rights is one of those. And it wasn't, nearly 2/3 of the states, but New York and New York and Virginia have both called for it through, Article 5 resolutions. And so, the Bill of Rights came from the Article 5 pressure process, not the official legislative process.
Right. So, and which, the term limits on presidential, on the president, I think came from some Article 5 pressure. 17th Amendment, as much as we don't like it, there was a lot of corruption at the time. And so that kind of pushed forward. But going forward again, back on Birch, but a guy that I really find intriguing, you mentioned the Liberty Amendments, Larry McDonald, who I would argue maybe is their biggest hero in modern times, Ron Paul's mentor, just a great guy, considered, I think, probably the most conservative congressman at the time in all of Congress.
Right.
Isn't it in the congressional record? I know it is because you have it on the Convention of States. Oh, by the way, go to conventionofstates.com. I'll talk about this later in closing, but if you're interested, a lot of this information we're talking about is there. But Larry McDonald, I find him intriguing. I don't agree with every one of his positions, but didn't he call for an Article 5, even the state side?
Yes, he did. He called for an Article 5 convention for the Liberty Amendment. And so, as did Robert Welch, who was the first president of the John Birch Society. And so I actually knew Larry McDonald a little bit. And I worked closely with his son on some education issues over the years. And so, he and I agreed completely on, I don't know of any issue where I actually disagreed with Larry McDonald. There may be some that I because I didn't know him that well, but everything I knew about, he and I are on the same side. And so, including the use of Article 5 to limit the power of the federal government.
Well, so reading that congressional record where he actually encourages states, he called, if I remember correctly, called for both Congress to push the Liberty Amendments forward and states. So I'm sure in that congressional record, there must be something in there where he expressed a fear that convention by the states would be run away. Am I not correct?
No, he did not. Because he believed the process of the Constitution.
So if that somehow, I'm sorry, Mike, but if he didn't express that fear in 1978, let's say, or thereabouts, somewhere around that time, I understand what you're saying about the letter, the Madison caution, and I almost think this is all that we really never had this until modern times. I mean, this irrational fear. Maybe they had concerns. Maybe even Larry McDonald in his private conversations, maybe he told somebody, well, we got to be careful. But this irrational fear, is this all out of the Schlafly burger? I mean, is that where you think this is 100% from that? I mean, maybe 99% from that?
Well, the modern iteration of it is 100% from that. And it's Warren Burger, although he delegated the duty to write Roe versus Wade to Justice Blackmun, he was the architect of Roe versus Wade. And there were 19 states that had called for a convention of the states to adopt a pro-life amendment, to reverse Roe versus Wade, when he was talking to Phyllis Schlafly. And of course, Warren Burger also contended that the Constitution of the United States was illegally adopted. He bought into the runaway convention of the original Constitution. And so, so here we have a guy that's wrong about how the Constitution was established. He's wrong on the right to life. He's wrong on a bunch of other stuff. And Phyllis is his friend because they're both on a presidential commission on the bicentennial. And she believes him, and he writes her a letter. And so 6 states repealed their pro-life calls for a constitutional amendment through the Article 5 Convention of States process because of Warren Burger's letter to Phyllis. And so we would have reversed Roe versus Wade decades earlier, but for that letter and but for Phyllis's efforts. And so Eagle Forum and the others that joined with her are responsible for prolonging Roe versus Wade for decades. For decades. Millions of babies have been killed because of the fear mongering that they engaged in.
Yeah, I agree. One of my favorite memories in my 12 years in the Senate, Mike, was when you came to Oklahoma. I knew nothing about Article 5 when I got elected, and I wasn't an attorney then, so that's my excuse, right? So I should have known, right? But and I think a lot of attorneys don't know it either, to be fair. But when I came in, so Josh Burkeen kind of handed me the baton. I found your phone number on the internet, Googling or whatever, had no clue who you were. This was 2014, I believe. And I called you. You picked up the phone, a constitutional attorney that's done so much stuff, and you just picked up the phone like it was just another phone call. So thankfully, I wasn't selling you magazines or anything, but you picked up the phone. We had a great conversation. You got your butt on a plane and you flew to Oklahoma, and you proceeded to engage in debates with the opposition. At that time was the Birch Society. Friends of mine, which I enjoy debating them. Their arguments are anyway crazy, but I so appreciate that. You're such a good man and so generous of your time and your passion to do that, which means it's in your heart. You believe in it. But I think my favorite part of that debate, at least the one that wasn't in the raucous basement in Oklahoma City where we got just harassed. But anyway, in the other one was when you walk through this concept of it's everybody's constitution. Do you mind walking our listeners and watchers? I mean, that was what the question was, if you remember, was, well, aren't you concerned about the other side and imperfect men? I think it was all around that. And you just walked us through it's everybody's constitution. Would you mind kind of walking us through the idea that it's not just the conservatives' constitution?
Sure. I mean, the Constitution is organically the ultimate act of the sovereignty of the people. And that was done in a 2-step process. The way it was done is that first, the state legislatures called for special conventions to name the delegates to the state ratification convention. So the people got to directly vote for people who were running to go to the ratification conventions to either vote yes or no on approving the Constitution. So it was done by the best available methodology to get a vote of the people. So people voted in delegates who approved the Constitution. So it was an organic act of the people, both morally and structurally. It was the act of the people. And so when it says we the people, it means it. It was we the people that did this. And it is the legacy and the authority of all the people to do it. And how we do it is through electing legislators to make rules for us. But when we elect people focused on the amending process, we're electing people for the purpose of limiting, in our case, limiting the power of the federal government or whatever else we think. And if there's enough people in the country who believe that the federal government is run away with itself or some other topic, they want term limits, or they want, no more court packing or whatever it is, when enough people in the country want that, then we have a constitutional amendment. It absolutely requires a vote of the people. And if there's not enough people who believe in what we're doing, it will not happen. There has to be a real movement of the people. And so the goal, but if you do this right now, ask the people of the country, do you think the federal government is too big? Overwhelming. All parties, yes. Do you agree with the idea that there should be limits placed on the power of the federal government to spend money and so on? Absolutely, overwhelmingly. So the people do, in fact, embrace our things. And so only those things that the people approve can be put into constitutional amendments. You cannot sustain a constitutional process without the people agreeing. And what this Convention of States process will do, it's remarkable. By putting the debate in a constitutional amendments convention, Article 5 convention, to consider particular amendments, it will be the greatest civics lesson in the history of the country. And so people will listen to that, and they'll get to hear people arguing why it's a good idea to have only one level of government having an education department, not three. Why it's a good idea to not let there be three levels of this department and that department. Why federal spending should be not gauged on our national the gross domestic product. It should be based on the actual revenue of the country for the government, because the gross, the idea that it's on the gross domestic product means the government thinks it owns all of our money, and it deserves a certain percentage of all of our money, and that's just not true. And so when you debate these principles, people are going to wake up, and our country will be so much stronger and better and more conservative and more aligned and more loyal, because the people will have engaged, and they will know it once again. It's not those guys in Washington, D.C. It's our country. It's our Constitution, and the loyalty will run very, very deep.
Well, I agree 100%, Mike. And I know we're getting close on time. I really appreciate all the time you've given. I know you're in Tennessee, right? So it's another good, strong state. But is there anything else? I mean, we've talked about Convention of States. We've talked about Patrick Henry. Is there any other thoughts or anything you want to share?
Well, I just want to give people encouragement that this can get done. 33 states have approved the Convention of States application in a committee. And if you can get something through a committee, it's possible to get it through the state, through the legislature. And so when people think that this is impossible, it can't get done, 33 states have gotten it through committee. And if we can get, and I don't remember the exact number, but I think it's like 28 states or something like that, have passed one house. And so we're at 20 right now. We can get to 34 if we can just stop fighting conservatives against conservatives, and all of us who believe in a limited federal government stand together and say, this is the way the founders gave us to limit the power of the federal government. Let's go limit the power of the federal government.
Amen, brother. I agree. Well, thank you so much, Mike, and look forward to lots of great stuff. And definitely let me know when you got your book ready and published it. I think that would be helpful to all Americans. So anyway, enjoy your conference there. Let me know anything you ever need, Mike.
Thanks, Rob. God bless you.
All right, God bless. See you.